I'm Denise Howell, and today on This Week in Law, we look at how the United States Supreme Court just rocked the world of patents and innovation. Or did it? Erik, Steve Nipper, and Matt Buchanan explain Bilski to us mere mortals. Plus, when does a laser become a lightsaber? All that and more coming up on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 68, Whiz, Bang, Click.
This Week in Law is brought to you by Audible. For your free audiobook, visit audiblepodcasts.com/TWiL.
Hello and welcome to This Week in Law. I'm Denise Howell, your host, and we are here for a show on all things patent law this week because we've had some interesting, or long-awaited, I guess might be the better descriptor, results from the United States Supreme Court on the issue of business method patents. Always on folks' mind in the technology arena. And we have with us three patent law experts to try and unpack this 71-page decision. First up, we have Matt Buchanan, a patent lawyer from Perrysburg, Ohio. Matt, welcome to the show.
Hi, Denise. Thanks. Glad to be back.
Glad to have you. And you were saying off air that you're going to try and keep yourself in good spirits despite the loss of LeBron James. And we appreciate that for the show.
I'll try.
Okay, good. If you need us to, get you a cup of water, something to lift your spirits, just,
or a free
in.
agent somewhere.
Exactly. Steve Nipper, also with us from Boise, Idaho, also a patent lawyer. Hi, Steve.
Hi, Denise. Thanks for having me again.
Great to have you back on the show. And also with us from Maynard, Massachusetts, and also a patent lawyer, Erik. Hello, Erik.
Hey, Denise. Thanks for having me back.
Great to have you back. We've been having a couple of issues with Erik's video that they're trying to sort out in the studio. At the moment, we can hear him but not see him. We hope to get that fixed up for you shortly if you are, in fact, watching the video version of the show. So let's get into this Bilski decision. Erik, you very kindly have put up a post that attempts to explain the Bilski decision to mere mortals. Now, I got to confess, I may need a mere mortal's guide to your mere mortal's guide because it's very, very detailed and a very useful post. But if we could have you explain to us mere mortals what exactly happened in Bilski.
Well, I think the issue with Bilski, which the Supreme Court decided on June 28, it was a threshold inquiry, which is not unlike a summary judgment sort of decision that a court would have to make about whether or not a patent application could proceed based on the subject matter of the patent. Mm-hmm. And the short story is that the Supreme Court said, no, it can't proceed because the financial hedging is drawn to an abstract idea.
Right. These Bilski people had a method for hedging commodities against weather-related risk. Do I have that right?
I think that's right, yeah.
Okay. And the court found it was too abstract, not subject to a patent.
Right. But it was a horrible case to go before the Supreme Court.
And why is that?
Well, because, and I think this is only a first inquiry. The patent application itself has never been examined. And there are some of the justices that talked to that sort of indirectly. But, procedurally, the State Street case was a much better case, because in that instance we were dealing with an issued patent, and here we're dealing with not only a patent application but one that hasn't even been examined yet. So the whole issue. I would have just dismissed this whole case and said it was not ripe for review, and sent it back. So,
well, it does seem like the court gave us 71 pages of wrapping around to not that dramatic of a result. I mean, on the one hand, they ruled against expanding business method patents. And on the other hand, they declined to make them any more difficult to get. And I guess the one nugget of concreteness that we have out of the decision is that this machine or transformation test, which I want to have one of you explain momentarily, that the Federal Circuit used, that applying that only is too narrow of a test. So, Steve, why don't you explain to us what the machine or transformation test is and why it's not enough on its own?
Well, that was a test that the Federal Circuit had kind of, that had come up with. They had come up with it. It evolved over time. Looking at Erik's excellent summary, I mean, if you really want to know how case law evolved, his summary is an amazing walkthrough of that. But when you're looking at this machine or transformation test, transformation's easy. When you're talking about a process, the process that is patented, there's this physical object that's transformed into something else. Easy to see when you're talking about a process of converting dairy waste into biogas. There's a physical process, or there's a physical change that's happened there. Typically, for software, for business methods, there isn't an actual physical transformation, and so a lot of them come in under the other leg, which is this concept of being tied to a particular machine, and even that has had has been difficult to define. What is tied to a specific machine? Is it as simple enough in the claims of the application to talk about a server, to talk about a client computer? Is that enough? And in some of those cases we've seen it is, some of the cases we've seen it hasn't.
Matt, why don't you let us know your opinion on why we needed 71 pages of discourse from the court to leave us with essentially what is the status quo before the case ever came down?
Well, answering your question as narrowly as possible, I would say that we don't. They could have resolved this case with a one-paragraph opinion, basically. But we all know what Supreme Court justices like to do, and they did that in this case. And I would actually say that it's important that they do that, because what they've done is, in saying that the machine or transformation test is not the exclusive test, they've kind of pointed it back to the Federal Circuit and said, you guys need to kind of figure additional parameters out on this thing as long as it's in line with our precedent and the statute. So the Federal Circuit wants to know what the Supreme Court thinks, and everything beyond that one paragraph they could have written, I think, will provide guidance for the Federal Circuit in coming years.
Tell me this. A number of the justices wrote a concurrence where they thought that business method patents should be out of the patent arena altogether. So clearly there's a number of folks on the court, not enough to carry the majority, but a number of them seem to agree with the rank and file of the technology world that business method patents are not only questionable, but probably not valid at all. What do you think, Matt, is the impact of that going forward?
Going forward, it's kind of interesting, because I think it reflects probably the views of the industry and maybe even society at large. I mean, the patentability or the eligibility of those methods for patent protection has been a hot issue for several years now, and it's an extremely contentious issue. And people are more than willing to share their opinion on it, whether they're on one side or the other. So I think it actually was interesting to see that the court, I think, reflects those divergent opinions. The current court, anyways, which actually changed right after this opinion, which is interesting too.
Yes, absolutely. Steve, can you explain to us what the difference is, if there is a difference, between a business method patent and a software patent? or is one just a subspecies of the other?
They're both processes. I mean, that's what we're looking at, from the standpoint of patentable subject matter. They're both processes. I don't know how you'd explain the difference between a business method and software other than just the application and what they're used for. I can't think of a distinction that I would make. Maybe Erik or Matt have a distinction they would make.
Do you, Erik?
Well, I think it's interesting that the 9-page State Street decision, opened the door for business method patents. When the ruling in that case was that the patent at issue, which was the subject of a licensing dispute, was ruled to be a machine. So the whole discussion. So really, what the court's holding in that case is that a computer implemented machine is not rendered unpatentable by the business method exception because no such exception exists.
Okay.
So it's sort of like day one in law school. What does the case stand for? So I've always thought that it was odd that case stands for the proposition that business methods are patentable subject matter. When the holding in that case was that a computerized machine is not unpatentable.
It seems to me like patent law in general may be lagging behind the world of cloud computing and software as a service, and so much taking place in software that is a true innovation. We're just not seeing things that live on CDs and in boxes on store shelves. What we're seeing is things that get rolled out as web services and live out their whole existence that way. Matt, do you think that affects the analysis, and are the courts able to take existing principles and apply them to this new paradigm?
I think actually that's squarely what the Supreme Court has kicked back to the Federal Circuit, without saying that they're doing that. Because as we see these new, software 20 years ago and even 10 years ago, like you said, it sat on a CD-ROM or on a floppy disk or on a specific computer, maybe a server, maybe a desktop somewhere. But software these days, it lives in the cloud. It's hard to tie it down to one particular machine, so to speak. It might span several machines, and the machines that it's on might differ from minute to minute even. So the Federal Circuit now has that issue to deal with. It's not before the court yet, of course, but they know that that's something that they're going to have to sort out in the wake of Bilski as more of these processes as eligible subject matter cases come before them.
Right. In one of the amicus briefs, this one filed by IBM, an argument was made, and I think the majority of the court agreed with this, that software inventions that make technological contributions are patentable. Now, Steve, that's some pretty general language. Can you conceive of an example for us where a software invention would be significantly technologically contributing to warrant a patent?
Yeah, I think that's a tough thing to say, because apply that to inventions in general. That the invention doesn't only have to be new and unique, novel, and has to be non-obvious, but there also has to be some kind of great whiz bang to it. I think the software people have that's the hardest part about when you're looking at software and IT as they look at patent law. To so many of them, no matter what the subject matter is, they have this feeling that the invention's obvious. That invention's obvious and should never have had patent coverage granted to it without really understanding what obviousness is. And I think that, in looking at the IBM approach to that, that's really what they're saying, is that, even if the invention hops through the hurdles to get a patent, it still has to have some kind of magical, whiz bangness to it.
The whiz bang test.
Yeah, I mean, I think that's what they're trying to say, that there's this real dramatic change in technology, that it isn't as simple as clicking once or clicking twice, but that there's some element that within it that's completely new. And it just, even in dealing with mechanical inventions or electrical inventions, that type of a difference where you really have some kind of a pioneering style patent doesn't happen all the time.
So let's look at some examples from history and try and apply them in the context of Bilski, or try and explain where they fit in the current patent framework. Let's look at Google search. Obviously, search has some patentable elements, even though this is an entirely web-based service that, again, doesn't live on a CD-ROM somewhere on a store shelf and get installed anywhere on your computer. Yet the algorithms that Google and other search companies use are patentable, I assume. And yet the concept of search would not be. Am I making a distinction there for your whiz bang test, Steve? That how you come up with the quality of search would be the patentable element, but the concept of having something go out and crawl the web and provide results in response to queries would not pass the test?
Well, I think that's the tough thing, is that there's been lots of ways of searching things in the past. And so, from a 50,000-foot standpoint, it's got to obviously be narrower than just search or search plus this. You really have to be doing something different than what everyone else has been doing that's non-obvious, is what the test equates to. Part of the problem in looking at all of this with respect to software in that Bilski case is the Bilski case, that invention was really something you can do in your head. And that was another problem with that case, is that the court really wasn't looking at this concept of patentability of software in defining those things, because it's really easy for them to look at it. And even if you read the opinion, that's what they did. They said, basically, it's an abstract idea. It's a process you can do in your head. It's not patentable, period. Perhaps down the road we'll get a case that really gets into greater detail regarding what is and isn't patentable subject matter. But for now, that's the rule.
Right. Erik, how does all this relate to Amazon's one-click patent, an infamous business method patent?
Well, I think the issue, one of the issues is that when you have any new technology, whether it's hardware, software, biotechnology, or anything else, there isn't good definable prior art for the patent office to search on, because one of the things that the patent office is really, really good at is searching patent documents, issued patents, and published applications. They're not good at searching elsewhere. So the trend of when a new technology comes out and a whole bunch of patents, arguably overbroad patents, are issued at the outset, is not one that's unique to software. It happens with every new technology. So if the concern is about the quality of patents, I think there's a simple change in the patent law that the USPTO or Congress could make, and that would simply be requiring every application to have a formal search done at the filing, because right now the rule is you only have to disclose that which you know about. And that's what leads to a lot of poor patents, because you're allowed to say with a straight face, yeah, we invented double clicking. And as far as we know, no one had even invented the mouse before.
Right. So ignorance is bliss as far as patent applications are concerned. Matt, is there any change on the horizon to that in the way of patent reform? There are constantly bills pending along those lines, but they also seem to languish.
Yeah, I think Erik makes a good point. There are always patent reform bills pending, it seems, and actually that's been proposed, requiring or putting a burden on applicants to submit some search data and things like that. But I think we could even accomplish something like that without amending the code, so to speak. I think I've long thought that the problem with the software patent issue is not carving software or business methods out of patent eligibility, making a specific exception either in the code or through case law. I've kind of always thought that it should be addressed on the patentability aspect. Like Erik said, and like Steve said, software guys have always kind of said, oh, well, yeah, this thing's patented, but somebody was working on this 12 years ago, and you know, that's not new. Like Erik said, the patent office didn't know that, because the patent office while they do a great job of searching patents and in recent years published patent applications, they are not very well equipped to search what we call non-patent literature, which is scientific journals and some other resources of prior art. And they're starting to do a pretty good job in the science, the life sciences and the hard science areas, because there's a structure for that. There's all these journals out there and it's cataloged and all that. But in the software field, it's just not something that's available to them. And I think industry could kind of solve this problem for the office by building a comprehensive database or web app or whatever it is that everybody contributes to regularly, and over time this thing will kind of become the go-to resource, not only for patent examiners but for everybody to kind of look at and date things. So when somebody submits a new patent application on a one-click business method, the patent examiner, of course, he'll first search for patents, first search for published applications, and he won't find anything. But then he'll go to this resource. And if it's true that somebody was working on that in 1989, he'll find it. And he'll reject the application because it's not new. It's not novel. So
right, so you're envisioning some kind of innovation data bank where whenever something novel comes along, like say RSS, the history of it is documented, and there could be debate about the origins and people involved, et cetera. But at least you have some kind of record and some kind of collaborative, community-moderated consensus as to what happened when.
Yeah, that's exactly right. And to some extent, the internet at large is becoming that, but the internet at large is inherently untrustworthy. So I think they would need to build a specific resource, that adheres to certain principles and policies and procedures and such. And there's actually precedence for this. The biotechnology industry has a tremendous resource where researchers submit new gene sequences that they discover, and they put them in a database that anybody can access. And patent examiners use it all the time. And we didn't carve those out of patentable subject matter. We typically rely on the patentability requirements when we're dealing with those types of inventions.
Sounds like a great idea. Steve, have you ever seen something like this in the making, or what do you think the chances of it coming together are?
Well, and I mean, that's always the problem with software. You start out, software's not patentable, software's not patentable. The only protection you're able to have is copyright and secrecy. And so throughout history, in having software, you've got source code that's locked down. No one knows how you do those things, and relying on copyright. And so all of that old information, all of that old knowledge isn't out there in a way that's searchable. And moving through that transition, that is the problem. I don't know what the easy solution for building that database is. I mean, the reality is that the court has indicated that software is patentable. I mean, that's the reality of it. You've got to deal with that. The two options you have are either to deal with patent reform and get Congress to change the law and carve out an exception, or you need to educate the patent office. I mean, those are the only two options. I've seen cases where people have gone in and had set up defensively. They had started to compile information in a particular area. You see that with some Wikipedia entries, for instance. I've seen people do that with respect to trademarks and arguments that a trademark's generic. actually building out a Wikipedia entry to put together all the information that the trademark side of the patent office would need to rule that a certain trademark was going to be generic. And there's no reason from a patentability standpoint, from a standpoint of discussing technology, you couldn't do the same thing. Really explain the background of the technology and how it's evolved. But there's just, as far as I know, I don't think there's a one place where technology is talked about like that.
Steve makes a good point about, throwing it to Congress and saying, hey, if you want to fix the Patent Act, fix the Patent Act. If you want to put an exception for software patents in like Europe did, amend the Patent Act to do so.
Yeah, that was going to be my next question is whether internationally other patent validating organizations have a smoother or do a better job of dealing with this issue. So in Europe, it's been expressly carved out that you can have software patents. Is that correct?
That you cannot.
You cannot. So they have been found to be too abstract, too vague, not sufficiently passing Steve's whiz-bang test.
Well, the difference in the United States is that patent reform acts that have taken place in the last few years, and you always see this, it ends up being IT and software versus bio and pharma on the other side, where you have IT that, they're pushing patent reform measures that are in their favor, some of which are an attempt to destroy the patent system. Pharma and bio don't like that, and so you have this great head-butting that never goes anywhere because they stall out. And what probably a sensible approach to dealing with reform would be for IT and software to specifically look at doing that, carve out an exception for their particular industry where you can't have patents in that area instead of attacking the system as a whole, because then they would lose a lot of that opposition that some of the other industry groups have. And I think Matt has even written about that before off of his blog.
Years ago. That would be an interesting
lost in the LeBron James haze at the moment.
It would be interesting to see them try to mount that because I'm not convinced that the industry could speak with one voice. They've spoken with one voice in reform efforts to date, because like Steve said, they've kind of lined up against pharma and biotech. But if they went in with the tactic of, all right, let's set up some exceptions or some rules that only apply to these types of inventions, software, maybe business methods, I don't think that they all agree on the issue that software should not be patentable.
And even furthermore, here's a dispute about patent law before the Supreme Court, something that happens very rarely, and we are debating over the meaning of words, and that's the court's job to do, is to explain to us what the meaning of words are. And in none of the three opinions does anybody try to define any of the following: abstract idea, software patent, business method. It's stunning, really, the lack of discipline that this opinion displays. I think this is probably the worst, most poorly reasoned Supreme Court decision I've ever read.
Wow. And Demian Dellinger over in our Facebook page would tend to agree with you, I think. He says, I think they've confirmed that the judiciary is not the place the necessary change will be made, which leaves the ball in Congress's court, God have mercy on our souls, until some corporation patents those too.
Except for the fact that the court didn't send its usual signals. They didn't say, we don't serve a legislative role, that's for Congress. They didn't say any of that stuff. They basically just punted it back to they basically punted everything back to 1982.
Well, but they did talk about, the language of the statute and the comprehensive nature of the eligibility section. But you're right. That is truly the only hint that they kind of gave as to, you guys need to go to Congress to deal with this.
Well, you guys have touched on. Sorry, go ahead. Finish your thought.
No, I was going to say, as a parent, it really reminded me of that, what you tell your kids, because I said so. That's what that case was. That the court really said, We didn't come up with this single test. Go back and look at our old case law and apply that law. And, period, closed case, without any explanation of what that even means. I mean, the poor Federal Circuit, I mean, that's what they're tasked with doing, is trying to take the handful of Supreme Court cases we have and try to figure out how to apply that law to today's cases. And so all these other cases are really an evolution of that, them trying to interpret older Supreme Court case law. And hopefully every once in a while we'll get a Supreme Court case that explains it better and redefines it for them, but not in this case.
I think that's the first time I've heard a patent attorney say the poor Federal Circuit.
Well, you could also say I would say you could also say the poor Supreme Court, because what this case really, I think, emphasized is that post-CAFC, they're really out of practice. They haven't had a lot of patent cases because all that stuff's been going to the CAFC.
Right.
And, the last decent patent opinion that came out of the Supreme Court was in 1982. So.
And that's interesting, because if you look at all the big, in the last couple of years, we've had a lot of big patent decisions from the Supreme Court. And I didn't notice it until Bilski, but maybe there's a trend running through those cases. It started with eBay, with the injunctive relief case, and they punted it, or they told the Federal Circuit, get rid of this little rule that you created and rely on our precedent. And they did the same thing essentially in KSR regarding the test for obviousness. And now they did the same thing with Bilski. It's kind of like they're sending a message to the Federal Circuit.
Erik, I like this part of your mere mortals guide where it talks about the good luck to you all clause.
Right.
And the court says the patent law faces a great challenge in striking the balance between protecting inventors and not granting monopolies over procedures that others would discover by independent creative application of general principles. Translation: patent law is challenging, but we, the court, choose not to give y'all the guidance you are desperately seeking. So thank you, court, for that.
Which is awful.
Sorry, go ahead.
I mean, businesses want certainty in the law, and that is more true in patent law than anywhere. I mean, that's what businesses want, and Bilski doesn't get us there.
Right. So you guys have mentioned gene patents a couple of times during our discussion, and the fact that patent cases don't come before the Supreme Court very often. We might get a gene patent case there, though, before too long, might we not? Isn't there one where gene patents were found to be products of nature and therefore not patentable? And don't you think that's an issue that might land up before the Supremes as well, Matt?
Well, it's a common misconception on gene patents. A lot of people think that when they get a patent on a gene, that they're patenting the gene inside your body. And you, just by existing, are infringing the patent. And that's just not true. Gene patents relate to...
It's good to know.
Yeah, it is good. It's reassuring. Gene patents relate to isolated versions or copies of genes that have been extracted and purified and so on and so forth, or otherwise manipulated by genetic engineering or something like that. And that's been a settled area of the law for some time, that those kind of things are patentable. Sub-issues pop up, of course, and they will continue to do so. But post-Bilski, at least the current court, as modified, seems to have a narrow belief that, Congress spoke when it wrote the eligibility section of the statute, and it wrote that broadly. And we've spoke on it before. These things are all patentable.
Steve, any thoughts on those lines?
No, I mean, I agree. It's back to Matt's, I guess, asked and answered test for coming out of the Supreme Court. I think that if you had a case that went up that was a gene case, I think they would punt right back to earlier decisions they had on that topic and say, go apply what we already decided. I don't think we're going to necessarily see any huge differences or huge cases there that I know of.
Erik, what do you think?
And besides, all this 101 hand-wringing and opinion writing is a colossal waste of time and energy, because, like I said before, none of this matters. Any practitioner that gets a 101 rejection, especially if it's computer related, generally just has to stick some additional words into the claim saying, a computer programmed to, and that satisfies the examiner. Right. This issue would be better solved by just having it be a checkbox and letting it go away, and letting the patentability of software and business methods and genes and, frankly, anything else under the sun be determined not by 101, but by 102, 103, 112, the other requirements for patentability, which, by the way, are referenced in 101, namely novelty and obviousness and utility. So, the whole notion that, because, if this court had ruled one way or another, it's going to mean that all business methods of all crazy kinds imagined by courts, commentators, and others are going to be allowable is simply not true, because 101 is simply the first checkbox of many that you have to check during the whole patent prosecution process, along the way from a bill becoming a law, a patent application becoming an issued patent.
And 101 for all of us non-patent lawyers specifies?
35 USC Section 101 is the clause at issue here. It is the clause that speaks to subject matter eligibility for patents, but it's only one of a handful of clauses in the Patent Act that define, what you have to do in order to get a patent.
Right. So if you pass that threshold, then there are further tests.
Then you're in the door.
Yeah.
And further, much more difficult tests, frankly. I mean, the vast majority of our efforts internally are spent not on 101 issues, but on 103 obviousness issues. Right. 95%, I would say, are on obviousness issues.
Right. So does 101 even really serve its gatekeeping role? I mean, what you're suggesting sounds pretty radical, Erik, unless the thing is just being more honored in ignoring it than actually having an effect.
I don't think it has a gatekeeping role. I've never seen one of the hypothetical examples given, including E equals MC squared, gravity, dog training, anything else. I haven't seen a single example that wouldn't fail under 102, 103, or 112. So I would let everything through 101, everything. It would greatly simplify prosecution. It would cut down on costs. It would cut down on office actions, and it would let us focus on the real issues. And gravity's not an invention.
What do you think, Steve? Is this our next push for patent reform?
It's an interesting concept. I don't know that I've ever heard anybody say we should get rid of 101 in a way, but it makes a lot of sense. It'd be interesting to see what kind of crazy inventions you have filed if you got rid of 101. I'd still like to, I guess I'll have to look and see whatever happened to that guy that was trying to patent movie plot lines and how far he got that. But I mean, occasionally you have those cases where somebody comes up with something new and a new argument as to how they're going to patent something. And I guess 101 is what kills those off. But Erik's right. I mean, when you're dealing with 101 in a business method or a software, a lot of times it's as simple as amending the claims to include the magic words that the latest Federal Circuit case said was okay. Whether that means dropping in a server and a client computer or other language. A lot of times that's all it takes to get over that hurdle. And then dealing with 102 and 103, which is novelty and obviousness down the road, is where the real battle's, fought.
Yep.
And that's, by the way, what Bilski has to face now. Not only has to go back and amend his claims to satisfy 101, but has to get past all the other requirements as well. Which is why, again, this is a poor case for the Supreme Court to use as any sort of precedential case.
Matt, any final thoughts before we move on to some non-patent subjects here?
I agree with Erik. I think it's a neat concept. 101 is kind of a sieve, but that's what Congress intended it to be. I think maybe the industry attacks on 101 grounds because that's the easy way out. If you want to attack things on patentability grounds, which is 102, 103, novelty and non-obviousness, that's where the hard work's involved. Like Erik said, that's the majority of what we do. as prosecutors, but it's also the majority of what the Patent Office does. And for them to do that, it gets back to the ability of examiners to reliably find relevant prior art. And for them to attack these applications on patentability grounds, they have to have access to that most relevant prior art, and they don't.
Well, I'm all for the law actually making sense and having meaning as opposed to just being, a hoop to jump through. So, Erik, it sounds like a great idea. Hope you get some traction on it. Well, keep us posted, okay?
Oh, I'll do that. I'll update that article.
All right. All right. So, interesting words from our copyright czar in the Obama administration, who has gone ahead and acknowledged the importance of fair use. Her name is Victoria Espinel, and in the process of unveiling the Obama administration's first joint strategic plan concerning intellectual property enforcement, she specifically mentioned fair use and gave it an endorsement as a good thing. Strong intellectual property enforcement efforts should be focused on stopping those stealing the work of others, not those who are appropriately building upon it. So, Matt, what do you think? Is this a good shot in the arm for the free culture folks? Is it a good indication that the Obama administration actually comprehends copyright law in all of its nuances and not just as presented by one industry or another?
I think it's carefully worded to allow both sides to take what they want from it. I mean,
and that was carefully worded.
I mean, people looking for an assurance that copyright law or copyright enforcement is important. They got a little bit. The share everything, share alike folks got a little bit too. So I'm not sure that it means much, actually.
Right. What do you think, Steve? Is this just a bit of PR?
Well, even in looking at the Wired article that you'd linked to that I guess will show up in the show notes, it includes a sentence that says the plan was applauded by both the copyright and the copyleft. I didn't even know that was possible. And that's like saying some patent reform was supported both by the pro-patent and anti-patent crowd. It has to, it must be unbelievably vague in general if both sides applauded it. So I don't know. I think a lot of times with the executive branch has these feel-good little czars that do things like this that don't necessarily really have a huge impact on what the long-term outcome is of an area of the law. So, well, I guess we'll see.
Yes, there's more on this over at Threat Level, as Steve mentioned, by Dave Kravitz. He has a post on this. So thank you, Dave, for your excellent coverage. And Erik, any thoughts on the Obama administration's copyright policy?
Oh, I thought it was better than nothing, so I'll take it.
Right. So as the copyright and copyleft continue their battle to the death, ASCAP has thrown down the gauntlet and is attempting to fundraise from its members specifically to combat the likes of Creative Commons and other free culture oriented organizations. And this popped up on Boing Boing and through other folks, specifically one person who apparently got this letter as a member of ASCAP and posted it up to Twitter. ASCAP tells its members that they are facing their biggest challenge ever. Many forces, including Creative Commons, Public Knowledge, the Electronic Frontier Foundation, and technology companies with deep pockets are mobilizing to promote copyleft in order to undermine our copyright. They say they are advocates of consumer rights, but the truth is these groups simply do not want to pay for the use of our music. Their mission is to spread the word that our music should be free. This is why your help is now vital. And they go on to ask to raise some money so they can urge members of Congress to support our rights. This, I thought, was just pretty blatant. What do you think, Steve?
Yeah, it seems strange that they're lobbying for $5 here and $5 there on raising money to lobby. It just seemed odd.
A little desperate too.
Yeah. Well, it's like I guess I don't know. I don't even know how you describe it. It's just bizarre. So from a lobbying standpoint, even instead of going after big donors after going after large corporate donors, to go after it almost in a pass the hat relief for a natural disaster kind of act it has that feeling of desperateness.
Yeah. Matt, any thoughts?
IP has become a wonderful cash cow in the lobbying arena in recent years, and apparently it's true in copyright just as it is in patent law.
Right. And Erik, are you going to be writing your check to ASCAP anytime soon?
No. But this relates to TWiL of a couple weeks ago when we were talking about the entertainment industry's broken business models. And I think this is yet another example of where their money would be better spent building a Hulu clone, building a YouTube clone, rather than complaining about the fact that other people have figured out how to make money off of this stuff in the internet age, and they haven't. It's not too late to build a YouTube clone. It's not too late to build a Facebook clone. It's not too late to copy good ideas that are out there, because, not every idea is patentable.
And the whole notion that, as recently as a couple of weeks ago when this thing went out, the industry's party line is they just want free access to our music. I think it just ignores everything that has happened in the post-Napster era, turns a blind eye to it.
Classic fear-mongering.
Yep. All right. Well, I do want to say in a moment here, a happy anniversary to the e-Sign Act, and talk about some of the ramifications of that and how we all deal with our contracts these days. But first, I would like to thank our sponsor, Audible.com. This episode of TWiL is brought to you by Audible.com. It is a leading provider of audiobooks, as I'm sure all of you well know, with more than 75,000 downloadable titles across all types of literature, including fiction, nonfiction, and periodicals. For listeners of TWiL, Audible is offering a free audiobook to give you a chance to try out their service. And one thing I love about Audible's service is if you are just sort of needing a recommendation, you don't have TWiL in front of you to give you a recommendation at that particular time, the Audible homepage is great for finding bestsellers and new releases. And that is where I stumbled on something that I'm going to download immediately when the show concludes. It's called Suck It, Wonder Woman, The Misadventures of a Hollywood Geek. I just cannot wait to listen to this book, and I have no idea who its author is. I hadn't heard of her before, so thank you, Audible, for helping me discover Olivia Munn, who I believe is a comedian. She reads the book herself, and she has essays in it such as, this one, What to Do When the Robots Invade. Yes, when. So Olivia seems to have some pretty fun and funny things to say. And I am on the verge of an imminent midsummer visit to Disneyland. And I am all for, spending quality time and being there in body and soul for my child when we go do things like this. But to be able to have Olivia there on my iPhone to clandestinely tuck my earbuds in when my son is otherwise engaged in Jedi training. And I know full well that Darth Vader's coming out in a couple of minutes, and I'd really rather be tuned into something else. I'm going to be really happy to have Olivia there to help out. So you too can download that book or another one by going to audiblepodcast.com/TWiL and signing up for the free trial of the audible.com service. Thank you so much, Audible, for your support of TWiL. So let's chat about the e-Sign Act, which is now 10 years old. Not too many people actually talk or know about the e-Sign Act because it's sort of like the promise of, in 2010, we all probably thought we'd be flying around in cars and doing various things that haven't quite come to pass. And electronic signatures, in my mind, fall into that category. We do have the Electronic Signatures in Global National Commerce Act, e-sign that is now 10 years old. But I never or hardly ever run into situations where someone is presenting me with a document that I may electronically sign. Now, I tend to use services in my own practice and in my own life that embrace the e-sign Act because I think it's a great way to accomplish these kinds of transactions. You cut out the need for fax machines and mailing back in ink signatures and things. And there are all kinds of commercial services, DocuSign and EchoSign come to mind that take advantage of this. But it really seems to be this very little known area of the law. And since I've got you three innovative lawyers on with us this show, do you ever see the e-sign Act? And does it have any future where we can actually leave behind our ink signatures and fax machines? Erik?
You know, one of the things that I did when I saw that article is I went and searched my 20-plus year archive of email to see if anybody had ever mentioned it to me, because I have pretty much all that email saved. And I have zero references to this. So the particular e-sign Act, no, I don't use it. You know, I'd sort of forgotten about it. I occasionally will electronically sign an Adobe Acrobat document. I occasionally have clients who do the same, but at least at my firm, we have either faxed signatures or scanned and then emailed signatures, but nothing truly electronically. I mean, I suppose at the patent office we do our little, ASCII versions of quote signatures unquote, but it's not really the same thing.
Steve, do you think this is because people just don't trust doing things in a new way, even though it's perfectly legal and valid?
Yeah, I don't know. I don't know why it never took off. You talk about the future of 2010. I'd seen a piece of web junk the other day that was the photo from the inside the Back to the Future car where he'd sent Marty into the future, and the Into the Future was July 5th, 2010 or something. It's hard. It is hard to imagine that if you went back 10 years ago, you would have thought that all business would have been done this way. And I don't think I've ever seen it done either. I mean, as patent attorneys, we're kind of spoiled in that we use what's called an S signature all the time. The patent office accepts them, and typically when we file something, we don't file with an actual ink signature. We type our name between slashes, and that's accepted. It's completely accepted. Today I had something I needed a client to sign, and I grabbed an Acrobat form, slapped a form field on it, and sent him an email explaining what I needed him to do. Put in a couple slashes. I guess on the screen that'd be this way. When you're looking at the on your end, a couple slashes, put your name in between it, and the patent office will accept that as a signature. So I don't know what's happened in 10 years, but at least the idea is there.
Yep. Burke in the Twit Cottage is talking about Acrobat documents being the most common place where you would find e-signatures being used. And as I said, I tend to use a third-party service where you can just upload your document and then it emails it out and you can have it e-signed via email. Matt, have you ever used anything like that? And do you think the e-sign Act is still a decade away from popularity and common usage?
It's interesting because in our legal practice, we don't. Maybe that's because lawyers by nature are just Luddites. But I think I see it every day in my non-legal practice life. When you go to the grocery store and you sign a little pad when you do your credit card transaction, I'm pretty sure that that's kind of enabled by the provisions of this law that say, when you want to sign an agreement, it could be a 30-page license agreement, or it could be your agreement to pay for something at a store. The electronic signature is okay, and that the business satisfies its record-keeping obligation by keeping that electronic copy. So I think we see it in everyday life as consumers and that kind of thing, but in our legal life, I just don't see it.
Well, one place where I'd love to see it, because nobody reads them anyway, is in the finance world. And there's a hysterical little tidbit here from the ABA Journal via David Latt's Above the Law blog, where Judge Posner of the Second Circuit, one of the most highly esteemed federal jurists in the country, if not the world, was giving a recent talk at the American Constitution Society and told people that, he'd just recently gotten hundreds of pages of documentation related to his home equity loan and didn't read them at all and just signed them. And having just refinanced myself, I can tell you, same thing. And my husband's a lawyer too. And, when do you ever read these things? It's boilerplate. And we talk about boilerplate on this show a lot, that you don't actually have very meaningful contracts with people when your contract is stuffed with provisions that are incomprehensible, many, many, many hundreds of pages long in some instances. And, they're enforceable, but on the other hand, they're somewhat meaningless. And David Latt just really blasted Judge Posner and said it's the kind of behavior one would expect from a person earning $35,000 a year and buying a $600,000 home 2 hours outside Phoenix circa 2006, but not from one of America's leading jurists, which I think is a bit unfair. What do you think, Erik? Would the e-Sign Act solve this? I mean, if we're not going to read our documentation, at least we should be able to sign it in a frictionless way, don't you think?
Yeah, I think that would be helpful, and I think to the point about boilerplate, I get a kick out of trying to negotiate away these boilerplate clauses that are inapplicable, and the other side is saying, oh, but that particular clause is rarely enforced, so it's just boilerplate. We've got to leave it in there. So whenever that occurs, I say, okay, that's fine. You want to have that clause in there, then I want to have the 2 full moons clause in there. The 3 full moons clause, which says if 3 full moons occur in any 1 month, then the contract is void.
All right, so I've already copped to not reading my loan documents. You 3 are all lawyers. Have you ever read your loan documents, Matt?
Of course, cover to cover. No, and it's not just loan documents. Anytime, I bought a car recently, you don't read the thing.
Yep. What about you, Steve? Do you sit down and take an hour and a half and go through your important documentation of life?
I would say I skim it at least. Well, you'd feel horrible as a lawyer to get burnt by something like that they put in something funky. So I think, but I think that most people don't. They just whether it's a end user agreement or whatever else, they flip to the bottom, check agreed, and move on. So maybe we need to start intentionally sticking in some fun clauses just to encourage people to read.
Easter eggs, legal Easter eggs.
Legal Easter eggs.
Yes. So that's our second good idea from the show, or maybe the third. We have the Innovation Data Bank, we have Trashing Section 101, and we have legal Easter eggs and documents. Great. All right. So checklist
and the
to
Whiz
be
Bang
continued.
Test.
Yes, and the Whiz Bang test. So I wanted to also get to a story here where, we talk from time to time about people getting in trouble with their employers by way of their online activities. And I don't know if you guys saw this video of the iPhone wars, or the phone wars, excuse me, where it's this funny little video where someone walks into a store and wants to buy a phone, and he really wants to buy an iPhone. But the salesperson is trying to convince him that the iPhone is not the be-all, end-all of the phone universe, and they have a rather entertaining back and forth about it. But the poor thing is the guy, Brian Maupin, if I'm saying his name correctly, has gotten himself actually suspended from Best Buy, his place of employment, because this video was so funny and went viral. And I guess Best Buy must have thought that since they sell phones, that it could be offensive to one or more of their actual providers. So that's a difficult thing. Did you guys take a look at the video, and what do you think about poor Brian being let go? Erik?
Yeah, I watched the video. I thought it was hilarious. And, Best Buy is free to do whatever stupid things it wants to do. And I think it did its employee a favor by suspending him, because he's gotten a lot more press out of this and is probably going to get a lot better job than working at Best Buy.
Right. Matt, do you think that that somebody's web antics or sense of humor should be able to have an impact on their job? I mean, most states have at-will employment provisions that make it so that you can get fired for pretty much anything as long as it doesn't violate federal anti-discrimination laws. Can we or can Brian do much more than simply be in a sympathetic position here?
Yes, I think employers should be able to react to such things. But if someone ever came to me seeking counsel on that, I would tell them, look, be reasonable. You remember the video a couple years ago with the Domino's employees, I think it was, where they were doing really obnoxious things to the food that they were serving out of the pizza place that could have affected the health of the customers. Now, there's a video that I think the company was fully justified in firing the individuals. And in fact, if they didn't, I think there would be an uproar. But this video here, I mean, come on, guys, be reasonable. I wouldn't have done anything in response to it.
Right.
It doesn't even mention Best Buy, so.
No, it doesn't at all. So, Steve, any thoughts on poor Brian's plight?
Well, it's a tough position to be in. As an employer, if one of my employees does something that insults one of my clients, I'm going to have a problem with that. And particularly if I run the risk of losing that client over the conduct of an employee. And so, freedom of speech doesn't go too far there. Whether or not Best Buy is really going to lose the Apple account because some, checkout cashier at a Best Buy made a video or whatever his job role was is probably pretty unlikely. And Best Buy, realistically, Best Buy probably could have handled it better. But, to the benefit of the person that created the video because of the fame and who knows what else will come out of this that they'll benefit from it. So, to some extent, he got the best end of the deal.
Yep. All right. Well, I have a good suggestion for Brian. I think you should go work for Woot, which is the company that got bought by Amazon recently. And speaking of great videos, they did the most incredible, if you haven't seen it, go out and find it on the web, video describing or announcing that they'd been bought by Amazon. There were monkeys involved. It was wonderful. So this is clearly a company with a good sense of humor. And one of the more humorous things they've done, Steve, you sent me this link. Why don't you tell us what it was? They've poked some fun at the AP.
Yeah, I mean, the AP had some policy they had released, I don't know how long ago it was, a year or two ago, where they basically said if you quote an AP article in a blog post or online that they were going to charge you, for 6 words, it was like so many dollars. It was a completely crazy system that they had set up, really trying to keep people from quoting small snippets of articles in blog posts, and probably also for dealing with, link blogs, like Drudge Report, where they really, you could go to the page and you basically learn everything you need to know about the news without having to read any of the articles, just by reading the half a sentence snippet they put there. And the interesting thing was AP sets up this policy and they want people to pay them for that. But yet when this Amazon Woot deal goes through, and they release a press release, the AP quotes a sentence or two out of the press release right in the article. And so Woot had mockingly put up a blog post asking for their $17.50 based upon the AP's rates that Woot wanted. And they'd also said instead they could buy the deal of the day, I think. So it was it's a nice way of pointing out the hypocrisy that the AP was engaging in.
Yeah, absolutely. $17.50, I think it was, for copying 17 words. So, it seems like a fair price. Okay, one final story for our show today. Actually, this is going to be our tip of the week. And our tip of the week is, if you're going to give your laser a lightsaber handle, you have to expect to face the wrath of George Lucas. Here we have a company in Hong Kong that's called Wicked Lasers, and it has a $199 gadget that is a full-blown laser. I don't think it's just a little laser pointer because it ships with various safety equipment and goggles and things. And it has what is suspiciously cast as something that looks like the hilt of a lightsaber. Now, they, of course, contend that that's not at all what this is. But face the wrath of George Lucas, they are. So tip of the week, give your laser some other kind of handle, because apparently toys like this are not part of the whole extended universe of licensed and approved Star Wars material. Matt, any thoughts on a laser with a lightsaber hilt?
I just pulled up the website. I'm going to order a couple. I've got 2 boys at home.
This probably passes the whiz bang test, though.
I think so. It's pretty cool.
Yeah.
I'm not familiar with the story, so I don't know exactly what Lucas was asserting against them. I'd be interested to see that.
Copyright.
Yeah, I would like to see what... I'm looking at their designs right now, and I don't know what his copyright is, what it covers exactly. Mm-hmm. But I'm still ordering a couple, so maybe I'll get a letter.
Yes, I know. There you go. The Streisand effect taking hold. You know, I mean, Lucas obviously wants to prevent people from capitalizing too much on their franchise, especially without their permission. But yeah, I'm sure that this company will sell a few of these as a result of the coverage. Erik, what do you think?
Yeah, it could be legit, could be bogus. There could be a design patent at play. It doesn't look. I read the story, and it doesn't look like the vendor was using the phrase lightsaber, although third parties were in describing it. So that's probably what got George Lucas's attention. And presumably there's some sort of subsidiary there that manufactures toys, and presumably that toy company has some patents and some design patents and maybe some trademarks. So it could be a legitimate dispute, but certainly on its face, it looks ridiculous.
What do you think, Steve? Is this something that Lucas should be concerning themselves with?
Yeah, I mean, it was interesting. They were really bringing up the copyright aspect. If the laser's handles looked exactly like, or I guess substantially similar to the handles of real lightsabers, I guess there's something. But if it's just a handle in general, boy, I'd hate to say that copyright covers that. That somehow their copyright covers the idea of a handheld laser sword. I guess makes me wonder if the homemade ones I made a couple of years ago for my kids for Halloween out of PVC pipe are going to be an infringement of their copyright as well. So
I saw your pictures of those. They were amazing. Those are so cool. You should, we'll put those in the show notes if people want to go check them out. Right. Great DIY project. And yes, someone in the chat room is pointing out that I called the thing a toy. I meant toy in the sense of gadget. It is not an actual toy. And I think that would be important in the dispute, because if you're making a toy laser with a lightsaber handle, then you're probably more likely to run afoul of Lucas's IP than if you're making an actual functional, utility-oriented laser, which I think this thing is. So that's our tip of the week. Our resource of the week, we have 2. One we have mentioned already. It is Erik Kiel's Mere Mortal's Guide to the recent Bilski decision. Definitely, if you are one who has been following that case or are just interested in its outcome and ramifications, Erik has done the world a huge service by not only describing the case in some detail, but also providing a huge lot of context to how we got to where we are, where that case could be decided. So thank you so much, Erik, for that. He's also interested in intellectual property law of all kinds from WIPO, the World Intellectual Property Organization. We have something now called WIPO Gold, which is free searchable intellectual property data and tools. It's a really nice interface. You can find it at wipo.int/wipo gold. It includes topics for technology, brands, design, statistics, WIPO standards, IP classification systems, IP law, and treaties. So really nice resource there from the folks at WIPO. So with that, we will go ahead and I think I'll let each of you give us any final thoughts that you have on our show and anything that we've covered here. Erik?
I would just urge everybody to go back and read the CAFC and the Supreme Court decisions in Bilski. Read all of them and make up your own mind and ask yourself, does it make sense?
All right. Thanks so much. Erik, you can find at erikjheels.com, and he's also at erikjheels on Twitter. Thank you so much for joining us again on TWiL, Erik.
Thanks again. Sorry I didn't have any pictures to share this time.
Yes. Oh, and also Erik is somewhat famous for his wonderful and very comprehensible drawings of complicated intellectual property-oriented concepts, and there's one included in his great Mere Mortal's Guide. So thanks for everything, Erik.
Thanks again, Denise.
All right. And Steve Nipper. Steve, any last thoughts on the show?
Erik's guide is it's pretty nice. It's printed out. It's 16 pages long, so hopefully there'll be an audible.com version of it pretty quick. But it definitely is worth looking at it. Nice work. I think probably what I would encourage people to check out is just released today, the Patent Office released a draft of their strategic plan. And I've put it out there and asked for comments, and I'll get you the links. You can put it in the show notes. But that's definitely something to look at there. What's going to be the goals and plans of the Patent Office in the next few years? New administration, a new director of the PTO. What kind of ideas does he have? So check that out.
Fabulous. Okay, and folks can find Steve when we're off the show at inventblog.com and at Nipper on Twitter. Thanks again, Steve.
No problem.
All right, and Matt Buchanan, final thoughts?
I guess I'd just say stay tuned. Bilski was kind of anticlimactic, and I think we'll see the issue of business methods and software patents for years to come, maybe in Congress, probably in the courts, and it'll be interesting to watch.
It will indeed, and I really appreciate all of you being with us to help explain it, a very dense and what can be somewhat somnambulant topic, but I think you guys did a great job of making it easily comprehensible and explaining why it matters to all of us. So thank you so much, all of you, and Matt in particular. You can find Matt at bipo.us is his firm site, and also he's Matt Buchanan on Twitter. Thanks, Matt.
Thanks, Denise.
Take care, all. We'll see you next time.